I arrived home from work to find Karen Thompson, the rotund and self-important HOA president, standing in my foyer room brandishing a printed amendment titled HOA Executive Quarters Provision. Her heavily lacquered lips curled into a triumphant smirk as she announced that, by her own decree, I was required to allocate 2 bedrooms and a bathroom in my 5-bedroom house for her personal use to accommodate what she termed community liaison needs. My stomach knotted with disbelief and fury at the audacity. This was no mere fine or curfew, but a direct invasion of my privacy and property rights. Neighbors peered through the windows, their expressions a mixture of shock and schadenfreude, as Karen paced through my living room, which she'd obviously never bothered to tour before citing fabricated clauses and waving her HOA seal as if it were a royal warrant. The scenario felt surreal. A woman who would find me for recycling a bottle a day late was now demanding literal rooms in my private residence. I clenched my jaw, determined not to yield to her grotesque entitlement. If Karen thought she could commandeer my home, she had another thing coming. I invited Karen to sit at my dining table, her palms slick with self-satisfaction as she plopped onto a chair that creaked under her weight. With a steady voice, I told her I wanted to review her bylaws. She thrust the amendment across the table, expecting blind compliance. Instead, I calmly pressed a button on my phone and initiated a call to my attorney, a specialist in property law and HOA disputes. I explained Karen's demand. My attorney's tone sharpened. That amendment is void as it violates state property rights statutes and due process. File suit immediately. I relayed this to Karen, noting her face contorted from smugness to panic. Yet, she refused to back down, claiming her HOA membership empowered her with quasi-governmental authority over every homeowner's square footage. That was the moment I realized I needed to expose her overreach with concrete proof. I recalled the hidden clause in our original HOA incorporation documents buried deep in an appendix which explicitly stated residential amenities could not be expropriated by board members for personal use. Within moments, I located the scanned copy on my home computer. As I displayed the clause on my laptop screen, Karen's veneer cracked. The legal foundation for her demand collapsed before her eyes. But she launched into a heated rant about elite governance prerogatives, until I cut her off by serving her with a cease and desist letter drafted by my attorney. That legal twist showing the judiciary could override her self-made edicts set the stage for our inevitable court showdown. Refusing to take the matter to local HOA arbitration, I filed an injunction in county court, charging Karen with abuse of office, trespassing, and violation of property rights. In a surprise turn, the judge assigned to hear the case was a former homeowner in our estate, Judge Lorraine Sanchez, known for her stern approach to entitlement and corruption. I saw this as an unexpected boon. Her reputation suggested she would not tolerate Karen's antics. In the days before the hearing, I gathered evidence. Emails documenting Karen's pattern of arbitrary demands, testimonies from neighbors fined for minor infractions, and the original annex prohibiting room seizures. I even found a hidden video from my smart doorbell capturing Karen rifling through my mail and peering into Windows footage I knew would shock the court. Meanwhile, Karen scrambled to recruit HOA loyalists as character witnesses, but most were reluctant once they heard of the injunction. On the day of the hearing, the courtroom packed with curious residents. Karen arrived in her signature floral blazer, clipboard in hand, radiating feigned confidence. I sat calmly in the plaintiff's seat, flanked by my attorney and Judge Sanchez's former clerk, now a court observer who nodded discreetly in support. When the proceedings began, my attorney laid out the timeline of Karen's demands, presenting the home rule clause and the smart doorbell recording. Karen attempted to defend her actions as necessary for community oversight, but her testimony veered into absurdity. She insisted that sharing homeowner spaces constituted enhanced neighborly fellowship. The judge's steely gaze never wavered as she methodically dismantled Karen's arguments, citing state statutes on property inviolability and disavowing any HOA power to requisition private living quarters. The turning point arrived when Judge Sanchez reviewed the doorbell video. Karen's furtive glances around my foyer and her whispered threats to charge me where words won't reach left her exposed. The courtroom collectively gasped, and I felt a surge of vindication as Karen's composure unraveled. That climactic moment, her covert surveillance turning into public evidence, sealed her fate. With a firm gavel knock, Judge Sanchez rendered her verdict. Karen's amendment was illegal and unenforceable. The injunction granted protection of my home, and Karen was ordered to pay legal fees and fines for trespass and abuse of office. Moreover, the judge suspended her HOA presidency for life and appointed a court-monitored trustee to oversee the HOA's reformation. Karen's expression crumpled into disbelief and despair as the bailiff escorted her from the stand. Neighbors erupted into quiet, respectful applause, relieved that the reign of petty tyranny had ended. In the evening hush after the trial, I gathered a small group of neighbors on my porch, where the wooden board bearing "Your Home, My Rooms" had been retired as a community monument to tyranny. We toasted with iced tea to property rights and the rule of law, celebrating the courage it took to stand up against entitlement. As candlelight flickered across their faces, I felt the weight of our journey. From shock at Karen's demands to the courtroom drama that restored our freedoms. And as I raised my glass, I offered one last thought to those gathered and to readers everywhere. Was it fair to publicly shame Karen in court? Or did justice demand we use every tool to protect our rights? Share your thoughts on right and wrong below. Dawn broke on Maplewood Township with a quiet sense of anticipation. The morning paper's headline blazed across the front page. Court evicts HOA president. Private space inviolable. Neighbors flagged down delivery drivers to grab extra copies. The letter carriers exchanged triumphant glances as they fulfilled the record-breaking run of papers. I sat on my porch steps, cup of coffee warming my hands, and watched as the community absorbed the news. It was no longer just my victory, it was ours. The court-appointed trustee, Ms. Felicia Bradley, initiated sweeping reforms that morning. She convened the newly restructured HOA board in the community center, laying out immediate actions. Repeal of all overreaching amendments, transparent financial reporting, and an overhaul of enforcement procedures. Ms. Bradley insisted on community input at every step, scheduling weekly open forums where any homeowner regardless of membership status could voice concerns, propose bylaws, or nominate board members. The twist of having an impartial overseer guiding the HOA's rebirth bolstered residents' trust and prevented power vacuums from reemerging. Meanwhile, Karen's personal ordeal took a swift and steep descent. Following the court's ruling, her bank accounts were garnished to satisfy restitution, and foreclosure proceedings were initiated on her home when she failed to pay both fines and her mortgage. News of her plight spread quickly. Former allies turned their backs as neighbors whispered about how Karen's self-aggrandizement had left her with nowhere to reside. One heart-wrenching afternoon, as I retrieved the mail, I spotted Karen's once immaculate home boarded up, windows shuttered and overgrown with weeds. A loan for sale sign stood at an awkward angle on her front lawn, a stark emblem of entitlement's consequences. In the midst of this upheaval, I collaborated with the trustee and Judge Sanchez to create a homeowner's Bill of Rights pamphlet, distilling our legal victories into accessible guidelines. We hosted workshops at the library where practicing attorneys volunteered to walk residents through common HOA pitfalls, and we distributed pamphlets door to door. These sessions not only empowered longtime residents but also served as orientation for new homeowners, ensuring that everyone understood the boundaries of HOA authority. Spring bloomed again as the HOA planted a community garden in the space where Karen's resentment once festered. Raised beds sprouted with tomatoes, basil, and marigolds, each seedling a symbol of growth from past adversity. I joined neighbors to build benches from reclaimed wood, using that same "Your Home, My Rooms" board as the seatback, repurposing a relic of tyranny into a bench of unity. Children scampered between the beds, learning gardening and the stories behind each planted row. The garden's mural, painted by local artists, depicted a kaleidoscope of flowers, homes, and interlocking hands, a visual testament to communal resilience. Summer's peak brought our first annual Maplewood Pick and Share Festivala potluck and Skillshare gathering in the park. Booths lined the pathways, one offering free legal consultations, another teaching DIY home maintenance, and a corner dedicated to HOA archives with copies of past meeting minutes and amendments. At the festival's heart stood a stage where Judge Sanchez awarded certificates to residents who had gone above and beyond in service. including Denise McAllister, the former HOA enforcer turned committee chair who guided neighbors through mediation sessions. Her redemption story elicited standing ovations and tears of pride, proving that transformation can arise from accountability. In the months that followed, local universities invited me to speak on panels about citizen-led governance and property rights. I shared Maplewood's narrative, how a single egregious act of entitlement could trigger legal redress, but also how community solidarity could ensure lasting cultural change. These speaking engagements sparked requests from other municipalities seeking guidance on drafting enforceable charters and enacting no-hijack clauses to prevent future expropriations. Meanwhile, Karen's life outside our enclave became a cautionary horoscope for other would-be power brokers. Social media documented her transient existence rooms rented by distant family, occasional stays in motels underscored by her anonymous pleas for understanding, all too late. One evening, I learned she had applied for a community service program to instruct new HOA officers on ethical leadership. The irony was not lost on me. I wondered if she sought atonement or simply a lifeline. Either way, the courts, honoring procedural fairness, allowed her participation under strict supervision. As the second anniversary of my court victory neared, the HOA organized a commemorative event, Founders Day, celebrating the principles laid out in our new bylaws on home autonomy and shared governance. Speeches recounted the 5 pivotal stages of our journey: the shocking intrusion into my foyer, the revelation of her bylaws' illegitimacy, the courtroom showdown, the collapse of Karen's presidency, and the dawn of a transparent HOA. I joined the final address, holding aloft the restored "Your Home," my room's board now polished and mounted on a plinth. I spoke softly. Today, we honor not just our resilience, but the idea that our homes are sanctuaries, not annexes for personal ambition. May this board remain a reminder. No one, no matter how assertive, can override our rights without accountability. Applause and cheers filled the park. Children chased bubbles that mirrored the resilience of our collective spirit. In the gentle glow of dusk, fountains danced with colored lights in the community plaza. Neighbors shared ice cream cones, and I reflected on our journey. From Karen's audacious demand for rooms to her ignominious fall and subsequent community-led renaissance, Willow Creek Estates had endured and thrived through trials of law, conscience, and solidarity. And though Karen's story remained a cautionary tale, our shared narrative transcended one individual's downfall. That evening, I typed one final post on entitled People Reddit. From forced room seizures to an empowered HOA, how our community fought entitlement and cemented home autonomy. Did we handle Karen fairly, or did we turn justice into spectacle? Join the debate on right and wrong below. As I pressed post, I sensed the enduring power of our saga, a testament that the true home is where respect for rights and each other thrives, not where entitlement reigns unchecked.